7, 6, 5, 4, 3, 2, 1.
The Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. I'd like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has previously been distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. Although the CDC has announced revised guidelines for individuals who have been fully vaccinated, yesterday afternoon, the Office of Attending Physician issued guidance that committee meeting spaces like the House chamber must continue to maintain social distancing and requirements that masks be worn at all times except when a member is recognized to speak. As these guidelines are updated, our procedures will be updated accordingly. In the meantime, I thank all members in advance for their understanding and cooperation. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself at any time you seek recognition. Pursuant to notice, I now call up H.R. 2694, the Criminal Judicial Administration Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2694 to amend Title 18, United States.
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.R. 2694, the Criminal Judicial Administration Act of 2021, is bipartisan legislation that makes two modest but important amendments to current law, promoting the efficient, effective, and fair administration of justice. The first part of this bill concerns out-of-custody criminal defendants, particularly those who are released pending trial and who live in communities that are located far from the courthouse where their cases are being heard. The majority of federal criminal defendants are detained pending trial. The U.S. Marshals Service is responsible for housing and transporting them to court hearings, including trial. Under current law, the court may order the U.S. Marshals to provide funds for a criminal defendant who is released pending trial but cannot afford the cost of travel to the location of the courthouse for required court proceedings. However, the defendant must fund their own way back home, and a defendant in this position is not able to receive financial support from the U.S. Marshals Service for subsistence such as lodging and meals. For an indigent defendant, these costs are sometimes insurmountable. For instance, a defendant from Hawaii who must attend a 2-week trial in the Southern District of New York would have to figure out how to pay for 2 weeks of lodging in New York City. Or a defendant released to live at home in the Navajo Reservation who has a pretrial hearing at the federal courthouse in Phoenix may not be able to afford gas for the 6-hour ride back home. For years, our federal courts have struggled with how to assist indigent defendants when they find themselves in these difficult situations. But unfortunately, the court's efforts have come up against the text of the statute. This bill would authorize courts, in the interest of justice, to order the U.S. Marshals to cover round-trip travel and subsistence for defendants who must attend court hearings, but who cannot afford to pay this on their own. The Judicial Conference has urged us to correct this grave unfairness, and I am pleased to see that we are finally doing so with this bill. The second part of this bill, concerning federal magistrate judges, is also supported by the Judicial Conference. Magistrate judges have trial jurisdiction over certain misdemeanors, except for Class A misdemeanors, for which the maximum sentence is up to 1 year in custody. With the defendant's consent, however, a magistrate judge may exercise trial jurisdiction over a case involving a Class A misdemeanor. Magistrate judges frequently do so, and often hear Class A misdemeanor cases all the way through judgment and sentencing. Under current law, a magistrate judge's jurisdiction ends after judgment is entered in a misdemeanor case, and post-judgment jurisdiction reverts to the district court. Indeed, magistrate judges are not authorized to hear post-judgment motions, such as motions to vacate a sentence, even though they are the ones that handled the entire matter at the trial level and are best equipped to hear such post-judgment motions. Among other things, this bill would authorize a magistrate judge to hear post-judgment motions in misdemeanor cases in which he or she exercised trial jurisdiction. This amendment clearly improves judicial economy and makes perfect sense. I commend Representative Jeffries, Representative Roy, and their other bipartisan co-sponsors for introducing this legislation, and I urge my colleagues to support this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you so much, Mr. Chairman. H.R. 2694, the Criminal Judicial Administration Act of 2021, comes at the request of the Judicial Conference of the United States. The bill strengthens existing laws regarding the transportation and subsistence for indigent criminal defendants. It grants magistrate judges greater authorities, which will increase efficiency. This committee considered the House passed, and the House passed similar legislation last Congress. I appreciate the Judicial Conference input on this legislation, Representative Jeffries' good work, and I want to thank the bipartisan sponsors for the legislation. And with that, Mr. Chairman, I would yield back.
Without objection, all other opening statements will be included in the record. Are there any amendments to H.R. 2694?
Move to strike the last word.
For what purpose does the gentleman from New York seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thanks so much, Chairman Nadler and Ranking Member Jordan, for your leadership and support of this incredibly important, modest, but important piece of legislation. Today, we are here to mark up H.R. 2694, the Criminal Judicial Administration Act of 2021, a bipartisan bill which passed the committee in the House unanimously late last year. This critical legislation would bring more efficiency and fairness to the criminal justice system by making two common-sense improvements to the administration of justice in America. First, the bill would authorize courts to direct the U.S. Marshals Service to provide subsistence and return transportation to non-custodial defendants who are required to attend court proceedings but are financially unable to do so to cover the costs of their participation. There is a very small group of defendants who are not detained pending the outcome of their case and must travel to attend court proceedings. While the law currently provides subsistence and travel to these proceedings, there is a gap in the statute. H.R. 2694 would expand the statute to cover transportation, lodging, and food for defendants returning home from these proceedings. And of course, embedded in our great democratic republic is the principle of innocence until proven guilty. Second, the bill would authorize magistrate judges to decide post-judgment motions in misdemeanor cases in which they have already exercised trial jurisdiction. Magistrate judges try and sentence individuals in misdemeanor cases, but to consider a post-judgment motion, current law requires a referral by a district court judge or the party's consent. This precision would facilitate judicial economy and help reduce the caseloads of district judges by removing this requirement. The more efficient we can make our court system, the more effective it will be. These two non-controversial changes would meaningfully improve the ability of our federal courts to deliver justice to the people they serve and come at the recommendation of the Judicial Conference of the United States, the national policy-making body for federal courts, which supports this important and necessary effort. I thank the committee for considering this bill today and really thank the original co-sponsors of this legislation, Representatives Chip Roy, Hank Johnson, Kathy McMorris Rogers, and Van Taylor for their bipartisan support. I yield back the balance of my time.
Move to strike the last
For what
word.
purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
I thank the chairman. I won't take too long. I appreciate the gentleman from New York for leading on this legislation. I'm happy to join with him on this. And as an original sponsor, as a former federal prosecutor in the Eastern District of Texas, I know full well what magistrate judges are capable of and be able to carry out the duties that this bill contemplates, which I think improve our judicial system significantly. And I was glad to support that with this backing, obviously, the Judicial Conference. And importantly, as the gentleman notes, with respect to the, I think, fairly modest but important changes with respect to make sure that individuals are able to get transportation and be able to get to the judicial system, that it does enforce, first of all, the idea it'll save, I think, taxpayers money in the end. But that actually doesn't matter here, in my view, as much, and that this fiscal conservative rarely uses that statement. But when you're talking about due process, when you're talking about the rights of those, when you're using the power of the state to deprive people of liberty, even in the pursuit of justice, I think it is critical that we have these kinds of resources available to make sure that justice is carried out fairly and impartially. And I appreciate joining with the gentleman from New York on this issue, and I yield back.
Does anyone seek recognition? Are there any amendments? If not, we'll proceed to a vote on the bill. All in favor say aye. Aye. Oh, wait a minute. A reporting quorum being present. Reporting quorum being present, the question is on the motion to report the bill H.R. 2694 favorably to the House. Those in favor say aye. 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 Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 2922, the Elder Abuse Protection Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2922 to amend the Elder Abuse Prevention and Prosecution
Without
Act.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. I am proud to support H.R. 2922, the Elder Abuse Protection Act of 2021, a bipartisan measure to establish the Elder Justice Initiative as a permanent part of the Department of Justice. The bill would also require the Elder Justice Initiative to post online materials for the public to identify elder abuse and report it, and it would charge the initiative with translating into Spanish the materials it prepares aimed at the public. In the months since this committee considered and approved this proposal by voice vote last Congress, elder abuse and elder fraud issues have continued to make national news. Sadly, we continue to see that physical abuse of the elderly can lead to premature death, debilitating physical limitations, and damaged psychological health. Emotional abuse can leave elderly Americans feeling fearful, depressed, and further isolated. Financial abuse can leave elderly Americans destitute and forced to make substantial adjustments to their lifestyle, and is particularly tragic as elderly Americans can see their whole life savings stolen away. The pandemic has only exacerbated these problems. For nearly a year, tens of thousands of seniors have lived in preventive isolation, making it more difficult for families and communities to address the emotional toll of elder abuse. Every community in the United States has been impacted by instances of elder abuse. A study in my home state of New York found that an estimated 1 in 13 elderly individuals had been victims of at least one form of elder abuse in the previous year. These numbers are astounding. Even worse, according to one study funded by the National Institute of Justice, elderly Americans who were victims of psychological, physical, or sexual abuse were almost 5 times more likely to be victimized again. The same study found that a lack of social support for victims of elder abuse was a uniquely predictive factor for depression, general anxiety disorder, and poor health. We must do more to interrupt the cycle of elder abuse. Preventive measures like those in H.R. 2922 must be expanded now. Unfortunately, existing efforts to address this issue have not been adequate to the task. Making available elder abuse resources that are accessible to all Americans is critically important. In 2016, the Department of Health and Human Services estimated that the Latino population in the United States aged 65 and over was almost 4 million. This is approximately 8% of the overall population of those aged 65 and over in the United States. To meet the needs of the Latino population, H.R. 2922 mandates that public materials on the Elder Justice Initiative website be translated into Spanish. Providing these translated resources will not only help Spanish-speaking older Americans find needed resources, but will also strengthen family bonds by educating Spanish-speaking caretakers to spot warning signs of abuse. In recent years, Congress has moved to enact legislation to help focus federal and local law enforcement efforts on elder abuse. In 2017, Congress enacted the Elder Abuse Prevention and Prosecution Act to prevent and curtail elder abuse and to improve law enforcement's response to victims of elder abuse and exploitation. Our colleague, Representative Ted Deutsch, was a leader in the House effort to enact that law. H.R. 2922 continues these efforts by permanently authorizing the Elder Justice Initiative to ensure that it can continue performing its important work, and by empowering older Spanish-speaking Americans and their families with the resources they need to reduce elder abuse. Elder justice and protecting the rights of older Americans historically has been a bipartisan effort, and I am pleased that this legislation continues in that tradition. I thank our colleague, the gentlewoman from Texas, Sylvia Garcia, for taking up this important issue, and the gentlewoman from Indiana, Victoria Spartz, for joining her in introducing this legislation. I urge all my colleagues to support this legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This legislation builds on President Trump's strong record of protecting America's seniors and responding to elder abuse in America. In 2017, he signed into law the Elder Abuse Prevention and Prosecution Act to improve the justice system's response to victims in elder abuse and exploitation cases. In 2018, President Trump signed an executive order that established a task force within the Justice Department that placed new emphasis on the growing problems of cyber fraud and fraud targeting the elderly. Attorney General Barr appointed a National Elder Justice Coordinator to oversee the department's work to combat elder fraud. Because of this work, all 94 U.S. attorneys' offices now have a prosecutor who specifically focuses on the most pressing elder justice issues facing their jurisdiction. The department also established an Elder Justice Initiative to support and coordinate the department's enforcement and programmatic efforts to combat elder abuse, neglect, and financial fraud cases and scams that target our seniors. This bill codifies the administration's Elder Justice Initiative as a program within the Department of Justice. President Trump and his administration led on protecting American seniors. This bill before us today will make permanent the thoughtful and successful initiatives implemented by them and Attorney General Barr. I'm pleased that my colleagues across the aisle recognize the leadership that existed there and are now passing this legislation. I too, as the chairman said, want to thank Ms. Garcia and Ms. Spartz for their good work on the bill. And with that, Mr. Chairman, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment to H.R. 2922, offered by Mr. Nadler. Strike all that follows.
Without
after
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes a few important changes to strengthen the underlying bill. For example, it provides the Attorney General discretion to place the Elder Justice Initiative within an existing division of the Department of Justice or make it an independent component. It also provides explicit authorization for the National Elder Abuse Hotline launched in 2020 by then Attorney General Barr. This hotline has already taken tens of thousands of calls from the public concerning elder abuse and elder fraud. In addition, the amendment adds requirements that the Elder Justice Coordinator coordinate efforts within the Department of Justice on tribal justice and legal aid initiatives. These coordination obligations are outgrowths of bipartisan initiatives started in the last administration. These are brief but important updates to this bill, and I ask my colleagues to support the amendment in the nature of a substitute. Are there any comments on the amendment in the nature of a substitute?
Mr. Chairman, move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you also to my co-sponsor, Ms. Sparks. I'm proud to sponsor this bipartisan Elder Abuse Protection Act. The act will ensure that our seniors, the group most disproportionately impacted by COVID-19, are not the targets of fraudulent crimes. 1 in 10 American elders are abused annually. This March, the Federal Bureau of Investigation Internet Crime Complaint Center released its 2020 Internet Crime Reporting, noting it received over 105,000 complaints from victims over the age of 60. That's a whopping 50% increase from 2019 of 68,000 complaints. An approximately 15% increase also was seen in the amount of dollars in loss of excess of $835 million. That's worse, and the statistics not only reflects complaints But it also must be mindful that this is people voluntarily saying they're over 60, so the numbers could be even greater. Victims over the age of 60 are targeted by perpetrators because they are believed to have significant financial resources. The evidence is clear. As the United States ages, diversifies, and modernizes, the number of older Americans experiencing elder abuse is unfortunately also projected to increase. Anything we can do in terms of measures for intervention is critical. Similarly, by 2060, the Department of Health and Human Services projects that the population of elderly Latinos will grow to 19.9 million, or about 21% of the overall American elderly population. It is estimated that 38% of Latinos in the U.S. use Spanish to communicate. Providing Spanish language resources to the public will therefore reach an underserved population and will provide an important resource to millions of residents in the United States, especially in my home state of Texas. The pandemic has made things even worse. Due to quarantine measures and limitation on visiting facilities and nursing homes, it has made it easier for abuse, neglect, and fraud to go undetected. That is why this important legislation makes permanent a national elder fraud hotline, requires the Elder Justice Coordinator to consult with the Office of Tribal Justice and designees on the legal aid issues. This bipartisan legislation is also supported by the Center for Medicare Advocacy, the Social Security Works, Elder Justice Coalition, the National Council on Aging, the American Federation of State and County Municipal Employees, and the National Academy of Elder Law Attorneys. Again, Mr. Chairman, thank you so much for bringing this issue to our markup today. As you noted, this was passed out of committee last session. There has been minor amendments, changes made as you presented. But I think what is the most important is that this is a great step in making sure that our elderly population has someone that they can call, someone that can complain to, and someone that will take up their case if they're subjected and targeted to any abuse of neglect, telemarketing, or any of the other internet crimes that exist today. So thank you, Mr. Chairman, and I also ask for unanimous consent to enter into the record the FBI's 2020 Internet Crime Report and a 2019 report by the U.S. Department of Health and Human Services, and the statement in support of the bill by the Elder Justice Coalition.
Without objection, for what purpose does Ms. Sparks seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Chairman Nadler and Ranking Member Jordan, for bringing the Elder Abuse Protection Act to markup today. And thank you to Congresswoman Garcia.
We have a technical issue we're trying to fix.
I think they can't hear me. They're fixing their.
Yeah, David, check your microphone. We're checking your microphone.
Can you hear me now? Chairman Nadler?
Still very, very, very soft. Hold on.
Okay.
Go to Mr. Correa. Okay, Mr. Correa. Yeah, pending resolution of the technical difficulties, I'll call on Mr. Correa now. For what purpose does Mr. Correa seek recognition?
Strike the last word.
With that, the gentleman is recognized.
Thank you, Mr. Chairman. I want to thank you and our colleagues for bringing this legislation forward. Our elders, our greatest generation, our grandparents and parents that built this nation, as they retire, they all what they want to do is live their last years as golden years. The vast majority of our seniors are, of course, on fixed income. Our seniors are the most vulnerable in our population, most vulnerable to being abused and victimized by criminals, some strangers, and sometimes even their own family members. And sadly, many of these seniors do not report the crimes when they are victimized. And many of our seniors already live isolated lives, and many more have another barrier, the language barrier, the cultural barrier. And of course, again, more seniors not reporting their crimes. As they stay silent, as they suffer quietly, we cannot let this situation happen. I want to thank you, Chairman Nadler, or my colleagues for bringing this legislation forward. We must do everything we can as Congress members to assure that our seniors are protected and that their precious life savings that they're relying on to retire are preserved. With that, Mr. Chairman, I yield.
For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chair, I have an amendment at the desk.
Reserve a point of order.
Point of order is reserved. Point of order. Point of order is reserved. David's here now.
Point of order is reserved.
Point of order is reserved. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2922, offered by Mr. Fitzgerald of Wisconsin. Page 2, line 6, insert before the semicolon at the end of the following, including this underreporting of
Without
nursing.
objection, the amendment will be considered as read. Gentleman will explain his amendment. Is recognized for 5 minutes.
Thank you, Mr. Chair. As elected officials, we have a duty to protect the most vulnerable. Nursing home residents make up 0.6% of the population, but account for nearly 1/3 of the nationwide COVID deaths, according to a recent report by the New York Times. This disproportionate death rate can be attributed to the decision by several governors in states like New York, New Jersey, Michigan, and Pennsylvania to effectively mandate that COVID patients be sent back to their nursing homes. In March of 2020, the CMS Administrator, Seema Verma, issued updated guidance stating that hospitals should not discharge a COVID patient to a nursing home that is not prepared to take care of those patients' needs under any circumstances. These states contradicted the CMS guidance by mandating nursing homes to take COVID-positive patients. In my own state, Wisconsin, Governor Evers and his administration quietly revised the numbers of nursing home patients who died of COVID-19 by nearly 1,000 deaths. These actions resulted in a tragic loss of life that is unacceptable and was largely avoidable. This amendment would add the underreporting of nursing home deaths related to COVID-19 and any improper use of a political office to shield a political donor who is a nursing home executive from a civil action related to COVID-19 at a nursing home to the responsibilities of the elder justice coordinators. I think it's time we take action specifically on this item, and I would urge my colleagues to support this amendment, and I would yield back. I also ask for a recorded vote.
The gentleman yields back.
I withdraw my point of order.
Point of order is withdrawn. I would oppose, I'll recognize myself for a statement in opposition to the amendment. I would oppose the amendment because it really deals with a different subject. The bill we're talking about deals with elder care. The amendment deals with health care. And I don't see that we should combine the two subjects as they're not directly related to each other. I yield back. Does anyone else seek recognition on the amendment? For what purpose? Mr. Issa, for what purpose does Mr. Issa seek recognition?
Strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. And along with striking last word, I want to include the breadth, because of the breadth of elder abuse, I want to include, without unanimous consent, that the following articles be placed in the record. One is entitled, Con Artists Intensify Their Telephone Scam Efforts in Pandemic. The second is, Spam Calls Annoying and Getting Worse. The third, how robocallers outwitted the government and completely wrecked the do not call list. And the third one is new FTC data shows consumer report losing $200 million in romance scams alone in 2019.
Without objection,
Thank you, Mr. Chairman. Mr. Chairman, on the underlying bill, nothing could be more important than to do everything we can to protect our elderly population and populations that are in many ways vulnerable that may not necessarily even qualify as elderly. There are many people who are impaired in any number of ways that find themselves answering their cell phone every day to endless scams. For more than 2 decades, or for 2 decades now, I have watched the Federal Trade Commission, the Department of Justice, the Security Exchange Commission, and the FCC each bounce the ball back and forth, telling this and other committees that they somehow lack the jurisdiction, the authority, or that they're doing all they can, or in some cases that they don't have enough money. So although I intend on voting for the underlying bill and I look forward to its passage, I want to make a point to the committee chairman that hopefully will be well taken, and that is that only through not just this bill, but a comprehensive review by those and other enforcement agencies for how it is that over 2 billion calls in some days and over 1 billion calls every day come to all of us, including the chairman, I have no doubt, completely circumventing laws that we have previously passed and with little or no consequences. There are multiple committees of jurisdiction in the Congress, but there is no committee with more direct responsibility for privacy and protection against fraud than this committee. And I would ask that in addition to today's markup, that we schedule all or even more than all of the names I just gave to come before this committee and begin to figure out how we can craft legislation that would once and for all effectively reduce or eliminate the kind of phone calls that come in both to our elderly and to others and constantly take their retirement and their security and their peace of mind away from them. And I thank the chairman for yielding. I look forward to supporting the legislation, but I wanted to make sure that we got this into the record, and I yield back.
the gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I oppose the amendment for exactly the reasons you described, and I think it's regrettable that we would attempt to politicize the deaths of seniors from COVID-19. So I urge my colleagues to oppose the amendment, and I rise in strong support of the underlying bill and thank Congresswoman Garcia for her leadership in introducing H.R. 2922, the Elder Abuse and Protection Act, and Ms. Sparks for co-sponsoring this bill. Reports estimate that as many as 1 in 10 elders are abused every year, but only 1 in 23 cases are actually reported. Protecting and caring for our loved ones who once supported and cared for us is one of our most honorable responsibilities. In 2018, a team of Brown University students conducted a year-long investigation that found in my state that 87% of those charged with elder abuse offenses between 2000 and 2017 did not go to prison for those crimes, leaving their elderly victims vulnerable to repeated attacks. Stay-at-home orders and quarantine directives have made it increasingly difficult for families to check on their older relatives, making it even more likely for fraud and abuse to go undetected. With our senior citizens disproportionately affected by this pandemic, it's especially urgent that we do all that we can to protect our loved ones from terrible crimes. Scammers who deceive a grandparent that their grandchild is in trouble and needs money must be held accountable. Imposters who pose as Internal Revenue Service agents to trick an elder into paying money they do not owe must be held accountable. Fraudsters who offer tech support assistance and claim to fix viruses detected on the victim's computer and collect money for fraudulent services must be held accountable. The Elder Abuse and Protection Act promotes justice for vulnerable seniors by making the Elder Justice Initiative a permanent office within the Department of Justice Criminal Division. That Elder Justice Initiative is charged with combating elder abuse, neglect, and financial fraud and scams that target our nation's seniors. Under the Elder Abuse Act, elder justice coordinators who work closely with the United States Attorney's Office are charged with evaluating training models and best practices to create publicly available material for local law enforcement and public officials tasked with investigating, interacting with victims of elder abuse, or addressing elder abuse. The Act requires publicly available materials and resources for local law enforcement and other professionals who work to investigate and seek justice on behalf of victims of elder abuse. It reemphasizes the need for culturally appropriate resources by requiring the Attorney General's office to translate materials into Spanish and help educate the public to prevent crimes of financial fraud against our seniors. Again, I urge my colleagues to support this excellent bill, and with that, Mr. Chairman, I yield back.
The gentleman yields back. For what purpose does the gentleman from Ohio seek recognition?
Thank you, Mr. Chairman. Strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. We're politicizing deaths. The gentleman from Rhode Island just said that the gentleman's amendment from Wisconsin is an attempt to politicize the deaths. For months, the governor of New York sent COVID-positive patients back into nursing home, 9,000 of them. And as a result of that, people died. And then they withheld that information from the Trump administration, withheld it until after President Trump left office. And why would they do that? For political reasons. And yet we're the ones who are trying to you got to be kidding me. This is a darn good amendment to a darn good bill. We should adopt it. We should get the information. This makes so much sense. But to accuse us of that when, in fact, it was just the opposite, and anyone with any common sense understands that, is just frankly not appropriate. I would yield to the gentleman who's the sponsor of the amendment, the gentleman from Wisconsin, if he would like to respond.
The gentleman is recognized.
Thank you. Thank the gentleman for yielding back. I guess, what we experienced in my state of Wisconsin was that early on, we didn't know what we were up against. And numbers were reported on a regular basis. If you turned on any local news station, they certainly had a count on how many deaths there were, how many people were recently infected. And we worked in cooperation with the governor of Wisconsin to kind of wrap our arms around it. But when are we going to have a discussion about nursing homes and what happened there? I guess that's my question, and it looks like, we're headed towards this is not germane to what we're working on today, but that would be my question. When is it going to be germane? When is it going to be important enough that we actually tackle it? Because there are a lot of families that are really disappointed and feel like they were let down by not only the governors, but certainly even in some instances, those that were working under the auspices of public health. And we had that in Wisconsin, and it still is something that's lingering. And if Congress doesn't hit it head on, if the state legislatures don't hit it head on, when are we going to deal with this? And that's why I brought it forth today, because I thought it was appropriate. And I would hope that the committee would consider it. I yield back.
I thank the gentleman for his comments. I think those are well taken. Mr. Chairman, I yield back.
The gentleman yields back. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. I want to thank my colleagues for Representatives Garcia and Sparks for sponsoring this important bill. We know that older Americans are increasingly vulnerable to financial scams. And amid the isolation and disruption of COVID, these scams have taken on a new twist, with fraudsters targeting seniors with schemes related to grandchildren in the hospital, Social Security benefits, and stimulus checks. Earlier this month, I unfortunately had to connect to two constituents who had lost close to $1 million, a lifetime of retirement savings during one of these telephone scams. These were intelligent professionals, informed citizens who fell prey to an elaborate network of schemes. And according to our local law enforcement, situations like this are too common. It wasn't the first or the second or the third report of people losing their life savings to a scam such as this that our local police and our local FBI had received that week. So it's heartbreaking that this couple lost hard-earned life savings to a scam, and unacceptable that our older citizens are consistently targeted. We need to do everything we can to counter the rise of these scams and protect our seniors from fraudulent schemes. And this bill will provide accessible resources aimed at preventing this kind of financial exploitation. After decades working as a board member and volunteer with our legal services community, I also know how important access to legal aid is. And this bill will help vulnerable seniors who are victims of abuse and fraud to access critical legal advice. So again, I applaud my colleagues for introducing this legislation, and I look forward to supporting its passage out of this committee. With that, I yield back.
The gentlelady yields back. For what purpose does the gentleman from Ohio seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to thank the gentleman from Wisconsin, Mr. Fitzgerald, for offering his amendment. I think it would make a good bill better and would urge my colleagues to support it. As to the underlying bill itself, I want to thank Representatives Garcia and Sparks for introducing this legislation, which I support, to further protect our nation's seniors from fraud and abuse. I want to note that in just a few short weeks, on June 15th to be exact, we will celebrate World Elder Abuse Awareness Day. It's a day to be mindful of the abuse and neglect that's too often experienced by elderly persons in the United States and in our districts all across this country, and in fact, all over the world. Our nation's seniors lose nearly $3 billion each year due to elder abuse and exploitation. That amounts to an average annual loss of $35,000 a year, which is a significant amount of loss to these seniors and their families, and it can have a lasting financial, mental, emotional impact on so many people across the country. The bill that we're considering this morning builds upon legislation that we passed a few years back and efforts initiated by the Trump administration to protect vulnerable seniors from abuse. It will help to provide additional protections to some of the most vulnerable adults in our society who hopefully will no longer fall victim to fraud, abuse, or substandard care in nursing homes and assisted living facilities. I want to again thank Representatives Garcia and Sparks for introducing this thoughtful legislation. I urge my colleagues to support it on both sides of the aisle, and I yield back.
The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
In this hearing, markup
Gentlelady is
rather.
recognized.
Ask to move to strike the last word. Thank you, Mr. Chairman. Sorry. Let me rise to support this legislation and to thank my neighbor, the gentlelady from Texas, Congresswoman Garcia, and of course, Mr. Sparks, for this work that has been ongoing but is crucially needed. As the beginning language of the legislation indicates, that this Elder Justice Initiative, in providing a coordination of a criminal enforcement public engagement efforts to combat elder abuse, neglect, financial fraud, scams that target elders, and to support and coordinate the efforts of the Elder Justice Coordinators designated under this particular bill. With that in mind, I think the gentleman from Wisconsin has a very good idea, but I believe that that is both a health matter and a matter that could garner bipartisan support if it was not framed as a got you amendment or legislative initiative. We had some tough times during the COVID-19, and many bad things happened in spite of good intentions. Being a fact finder, I think, would be important, and that is something I'm sure can be considered prospectively. But I think it's important to note that the chairman has set the agenda for this committee, and he has set a very profound agenda, and I thank him for his leadership. Maybe we'll have an opportunity for common ground as we go forward. My hometown of Houston has a large Hispanic community, and so I'm particularly sensitive and pleased at the language generated by my colleague from Houston, Congressman Garcia, and our co-sponsor dealing with Hispanic community. I'm particularly concerned about the efforts to exploit elder Spanish-speaking constituents. In Texas, 20% of Hispanics are 65 years or older. This population is expected to grow more quickly than other ethnic minority groups, from numbering over 2 million in 2005 to 15 million in 2050. By some estimates, by 2028, elder Hispanic Americans will be the largest elder American minority group. That means the largest target for elder abuse. Within the Hispanic community, over 40.4% of older adults experienced some form of abuse and or neglect within the previous year. Of those that reported abuse, nearly 25% reported psychological abuse, 10% or almost 11% indicated physical assault, 9% reported sexual abuse, 16%, close to 17% indicated financial exploitation, and almost 12% were neglected by their caregivers. Spanish-speaking older Americans are particularly vulnerable to abuse. One study of this population found that limited English proficiency was a barrier to accessing medical and social services. And many Hispanics, especially older Spanish-speaking Americans, may find themselves linguistically isolated and unable to communicate with those whom they live on account of language differences. And so this legislation, as it relates to elder abuse overall, is crucial because they are really part of our most precious resources. They're the shoulders upon which many of us stand, and they certainly are the brawn and the intellect upon which this nation was built. I always believe that you give respect and dignity to your elders because they are wise and they have laid the groundwork for you. So I look forward to the passage of this legislation. As I said, I would pose the present amendment and support the underlying bill and ensure that the Department of Justice is prepared to include these new resources for Hispanic seniors, including such translation efforts that could have an even broader effect because cash-strapped local governments for which the cost of translating materials is often prohibitive could use the Spanish language elder abuse materials prepared by the DOJ and distribute them to their communities. To be isolated, to be targeted, as all of our seniors are, with all kinds of scams that come over the telephone. I have received scams, and I am fully in touch of saying that our Social Security is under federal investigation, and we need to immediately give our Social Security number over the phone. Can you imagine being language challenged, hearing a screaming person over the phone indicating that you're about to be arrested? What an outrage. And so this is a very important initiative, including the hotline. I thank my colleague for bringing it, and as well, thank Chairman Nadler for having this on our agenda today, and ask my colleagues to support the elder abuse legislation before us today, H.R. 2922. I yield back.
Gentlelady yields back. For what purpose does Mr. Roy seek recognition?
I'm going to strike the last word.
Gentleman is recognized.
I thank the chairman, and I'm glad that we're having a conversation in this committee on this important issue. I believe that there's generally bipartisan support for the underlying matter. I do want to rise in support of my friend from Wisconsin's amendment because I think it's important. And, you know, we're talking about elder abuse, and I'm trying to figure out what could abuse the elderly more than shoving them into nursing homes in the middle of COVID, and then potentially having some of our top public officials in this country then lying about the facts surrounding that. I mean, in what universe is that not relevant when we're talking about elder abuse? I would note that the governor of New York on March 25th issued an executive order that shoved more people, more elderly, back into nursing homes. And then later, of course, there's the issues about then the veracity and the truth of the information being shared by the governor. On March 20th of last year, I wrote an op-ed in the National Review that said we need to get our country back to work on a date certain. At the same time, if you go back and look, I launched an effort in my district to try to protect the elderly, encourage people to go help the elderly, make sure people are being protected in the nursing homes, because it was clear to me, and it was clear to anybody who knew what was going on with the virus, that the elderly were particularly susceptible to the illness, and that we shouldn't shut our economy down, kill small businesses, shove our kids into the back rooms and corners of schools, put masks on them and scare the heck out of them. And instead, we should protect the most vulnerable among us. Instead, we chose a different path in many respects, and now we're facing the consequences of 100,000 small businesses that have been closed. We're seeing mental health issues rising. We're seeing children who are having more and more issues. We're seeing higher suicide rates. So I think the gentleman raising this issue is actually important, because what we saw coming out of, at least with respect to the governor of New York, is highly problematic. I mean, we know, for example, that the Democrat Attorney General of New York offered the first evidence of allegedly falsified data when she revealed that Cuomo's team underreported nursing home deaths by as much as 50%. According to the Associated Press, nearly 15,000 nursing home patients died from the coronavirus, not the 8,500 that they had put forward. And then came the stunning admission by DeRosa from the Cuomo team in a private phone call with Democrat lawmakers that the numbers were doctored to shield against a federal investigation. I think these are legitimate questions when we're talking about the abuse of the elderly. And I think we ought to have these conversations because we're seeing what actually transpired as a result of the actions of some of the leaders in our nation, particularly the governor of New York. And so with that, I would yield back.
The gentleman yields back. For what purposes Mr. Tiffany seek recognition? Gentleman is recognized.
Move to strike the last word. Thank you very much.
Gentleman is recognized.
Mr. Chairman. I rise in support of the amendment from the gentleman from Wisconsin. And just a quick note, I worked with Representative Fitzgerald for years in the Wisconsin State Legislature, and as you're about to find out here today, as well as over the last few months, that he is very thoughtful in how he goes about his work. You don't see the bombast, stuff like that. I mean, this amendment is germane to what we're doing here, and he has brought this forward in a very thoughtful manner, and I thought he gave very good reasoning of why this amendment should be, that it should be taken up and it should be passed. And it is all about accountability. And I think about a couple of the words that were said on the other side of the aisle that I thought were very appropriate in describing this bill. They pointed out, used words like heartbreaking, protect. What better can we do to prevent the heartbreak of what happened to people that were forced into nursing homes in New York, Pennsylvania, Michigan, other states? We still don't know all the answers in Wisconsin as far as what happened there, as far as the numbers being revised recently. And it is nothing but heartbreaking for those people who suffered that loss. And when they look in the rearview mirror and they say, wow, this could have been done differently, that they could have been protected. And so I think this measure is all about accountability. And it is something that's so important for us to do in this legislative body, is to make sure that people are accountable for their actions, if for no other reason, and probably for the most important reason, is for the future, so we don't make the same mistakes in the future. I yield back.
Gentleman yields back. For what purposes does Ms. Garcia seek recognition?
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I rise to oppose this amendment. While I'm very sensitive to the concerns that are raised in this amendment, because certainly the underreporting of nursing home deaths has been a concern, not only in New York, but in Texas, and as noted earlier, in many of our states. However, this bill is not about nursing home reporting. It is not a healthcare bill. I think that while it may arguably be germane, it is really not relevant to the intent of this bill. I mean, this bill is about financial fraud, scams targeting our seniors, the telemarketing. It's about fraud. It's about abuse. It's not about nursing homes. I think this is an amendment, and frankly, probably a good topic for a good bill in another committee of jurisdiction, but it would not be in this committee. So with that, I urge all my colleagues to oppose this amendment.
Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No.
No. Mr. Chair, I'd ask for a recorded vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Mr. Cohen. Mr. Cohen votes no. Ms. Jackson Lee. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Swalwell. Mr. Liu.
No.
Mr. Liu votes no. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Jayapal.
No.
Ms. Shyfall votes no. Ms. Demmings? Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
Scanlon votes no.
Ms. Scanlon votes no. Ms. Garcia?
Garcia votes no.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Mr. Stanton?
Stanton votes no.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar? Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Issa? Mr. Buck? Mr. Buck votes aye. Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes aye. Mr. Owens? Mr. Owens votes aye.
Ms. Jackson-Lee?
Mr. Chairman, how am I recorded?
Ms. Jackson-Lee, you are not recorded.
No.
Ms. Jackson-Lee votes no.
Mr. Cicilline?
Mr. Cicilline votes no.
Ms. Demmings?
Mr. Swallow recorded?
Ms. Demmings votes no.
Ms. Demmings votes no.
Mr. Swalwell?
Swalwell's a no.
Mr. Swalwell votes no.
Mr. Chairman, how am I
Mr.
recorded?
Swalwell, you have to turn on your video.
No, Stephanie, sorry, one second. Swalwell votes no.
Mr. Swalwell votes no.
Bass?
Ms. Bass?
Bass votes no.
Ms. Bass votes no.
Escobar?
Ms. Escobar?
Escobar votes no.
Ms. Escobar votes no.
Ms. McBath?
McBath votes no.
Ms. McBath votes no.
Are there any other members who haven't voted who wish to vote? The clerk will report.
Mr. Chairman, there are 17 ayes and 22 noes.
The amendment is not reported. Are there any other amendments to the amendment in the nature of a substitute? If not, we will proceed. The question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor say aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 2922 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, and the staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2746, a bill to amend Title 28 United States Code to redefine the Eastern and Middle Judicial Districts of North Carolina for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 2746 to amend Title 28, United
Without
States Code.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. HR 2746 would redefine the boundaries of the Middle and Eastern Districts of North Carolina to place Fort Bragg and Camp McCall, I hope I'm pronouncing it properly, a sub-installation of Fort Bragg located roughly 40 miles away, entirely within the Eastern District. This bipartisan legislation, introduced by our colleague, Congresswoman Ross and Congressman Hudson, has the support of every member of the North Carolina congressional delegation, including our colleague, Mr. Bishop. Even though Fort Bragg sits on the outskirts of Fayetteville, which is in the Eastern District, the base straddles both judicial districts. The result of this split means that a federal case arising in one part of Fort Bragg will be heard at the Fayetteville Courthouse, which is roughly 20 minutes away, while a case arising in another part of the base could be heard at courthouses more than 2 hours away. The logistical difficulties resulting from Fort Bragg's split jurisdiction can extend beyond the inconvenience of unnecessarily long travel times. In criminal cases, for example, courts have had difficulty ensuring that defendants have received notice of their rights. Ms. Ross's bill will fix that. I want to thank Ms. Ross for championing this legislation, and I want to recognize the efforts of Mr. Bishop as well. I am pleased to support this bipartisan legislation, and I urge my colleagues to support it as well. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This is, as the chairman indicated, just good common sense. Fort Bragg, which is located in North Carolina, is one of the U.S. Army's largest military installations. It is spread out over 6 counties, as the chairman said, roughly 250 square miles. Because of its size, Fort Bragg is currently located in 2 districts, the Middle and the Eastern District of North Carolina. And this split, as the chairman has indicated, is it's just inconvenient for courts and for defendants. HR 2746 redefines judicial districts so that Fort Bragg and the sub-installation Camp Mackle are located in a single judicial district, the Eastern District. The change will improve judicial economy and efficiency. I, too, want to thank Ms. Ross and our good friend, Mr. Bishop, for their good work on this common sense legislation that will help everyone. I urge a yes vote and yield back.
The gentleman will yield back. Without objection, all other opening statements will be included in the record. Are there any amendments to H.R. 2746? For what purpose does Ms. Ross seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
The gentlelady is recognized.
Thank you, and I want to thank you and the ranking member, and of course, I want to thank all of my colleagues in the North Carolina delegation.
Would the gentlelady suspend, please? There's something, there's reverberations, something's wrong with the sound. Yeah, one moment.
And I can go down.
Yeah. It sounds as if the gentlelady may be connected by 2 devices at the same time. Until that's corrected, we'll go to Mr. Bishop. For what purpose does Mr. Bishop seek recognition?
Thank you, Mr. Chairman. I think I'd like to just, if I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. I know that this bill was brought forward by former member George Holding of North Carolina, and I appreciate his efforts. It is always striking, I think, to a member who's fairly new here, how difficult it can be, or how much resources and time can be consumed in making even the simplest change in law. This is a very straightforward administrative change to make the administration of justice in North Carolina function more efficiently. I think it's just as simple as that, and I thank the chairman and the ranking member for bringing forward the bill to this markup, and I encourage support. I yield back.
The gentleman yields back. We'll try Ms. Ross again. Ms. Ross?
Thank you, Mr. Chairman. Can you hear me now?
Suspend, please. It's not fixed yet.
Okay.
Yeah. Okay, never mind that. Recognize Ms. Ross.
Mr. Chairman, can you hear me now?
Yes.
Thank you. I just wanted to point out, in addition to the facts that you've shared, that this is also bicameral legislation supported by both of our senators, and it is supported by all of our judges.
I'm sorry, Ms. Ross. Suspend. It's just not working. If you're in the building, if you can come to the committee hearing room, it would be much better. For what purpose does Mr. Johnson seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to recognize Ms. Ross, my colleague and member of the court's subcommittee, which I have the honor of chairing, for championing this bill. This is an important piece of legislation that is an exercise of Congress's constitutional obligation to ensure that the federal courts are serving the ends of justice in a way that enables efficiencies for the people who the courts serve. My friend and fellow member of the court subcommittee, Mr. Stanton, championed a similar bill last Congress, and I know that it's made a meaningful difference to the people of Arizona, and particularly those living in Indian country who used to have to drive hours just to have their day in court. Ms. Ross's bill will have the same kind of benefits for the people of North Carolina, and especially for the service members and civilians working on Fort Bragg, who will be spared a 3 or 4 hour round trip just to get to court. So I want to thank Congresswoman Ross for introducing this important quality of life legislation, because it improves access to justice, which fosters public confidence in and respect for the rule of law. And I urge my colleagues to support this legislation. And with that, I yield back.
The gentleman yields back. Who seeks recognition?
Mr. Chairman.
Does Mr. Biggs seek recognition? Gentleman is recognized.
Thanks,
What purpose does the gentleman seek recognition?
Mr. Chairman, I have an amendment at the desk.
Sir, a point of order.
Point of order is reserved. Clerk will report the amendment.
Mr. Chairman, can the second point of order be reserved? Now that I've seen it, I also reserve.
Multiple points of order are reserved.
I'd like to reserve one as well, Mr. Chairman. So.
I don't think you qualify. Gentleman is recognized.
Thank you, Mr. Chairman. And I support the underlying bill, and I support the rationale that my friend from Georgia just said, that the Congress' duty is to ensure that the federal courts ensure justice and efficiencies for the people who are served by those courts. I'm offering this amendment here because I think it is relevant to Congress making some adjustments in North Carolina. We need to make some adjustments in the biggest circuit in the world that stretches from the equator to the Arctic Circle. That is more than 3 times the size geographically and population-wise of any other circuit. It is so big that you can't get an en banc hearing that is normal. Because we have so many judges, what they'll do is they will just pick willy-nilly from a hat. And that's where you go for en banc. I appreciated particularly Mr. Johnson's reference to the adjustment we made in Arizona's federal courts to allow my friends in Arizona who live on the reservation of the Navajo Reservation to give them access to the court because it takes hours. Now, imagine that instead they have to go to the court in San Francisco. In order to get to Phoenix, it's a 4-hour drive, make arrangements, fly, stay in San Francisco to deal with your quest for justice. This bill, or this amendment that I'm requesting we consider today, would make those adjustments necessary. It is something that I know that some on this committee have long advocated for. I've advocated for it for many years. It is something that I think is relevant, it's germane, it works, and it gets to the underlying purpose of what Congress does. Make sure that, in this committee in particular, make sure that people have access to justice in our federal courts with efficiency, just as the gentleman from Georgia said. And so with that, Mr. Chairman, I'd urge support and passage of this amendment.
Clause,
I insist on my point of order, Mr. Chairman.
gentlelady insists on her point of order. Clause 7 of House Rule 16 prohibits amendments that are on a different subject matter than the proposal that is under consideration. The subject of the bill we are currently considering is the boundaries of judicial districts in North Carolina. The gentleman's amendment proposes to make changes to other judicial circuits, which is a subject that is different from what we are considering in this bill. The amendment is therefore not germane and violates Clause 7 of Rule 16. Does the gentleman wish to be heard on the point of order?
I do, Mr. Chairman, please.
Gentleman is recognized.
Thank you. I appreciate I appreciate you using the rule, but I believe that you're using too narrow of an interpretation of what's germane here on the bill. What you're really doing is, as the gentleman from Georgia just pointed out, you're actually expanding and dealing with the federal court system in a way that would provide justice and efficiencies to the people who are subject to that federal district court. That is why he referred to what happened in Arizona last year. And I am suggesting to you that this bill, or this amendment, is in the same vein. It is providing justice and efficiencies in the federal system, and that's why this amendment is germane, sir. I yield back.
And the gentleman yields back. I am unpersuaded by the gentleman's excellent argument. The amendment is still not germane. Are there any other amendments?
Mr. Chairman, I appeal the ruling of the chair and request a roll call vote.
Move to table.
Motion to table is not debatable. All in favor, say aye. Aye. Opposed, nay.
No.
The amendment? The ayes have it.
Request a roll call, please.
The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries.
But you don't see anything done regionally to...
Mr. Cicilline. Mr. Swalwell.
Yes.
Mr. Swalwell votes yes. Mr. Liu. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Stimmings.
Aye.
Ms. Stimming votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse. Ms. McBath. Mr. Stanton.
Stanton votes aye.
Mr. Stanton votes aye. Ms. Dean. Ms. Escobar.
Escobar votes aye.
Ms. Dean. Mr. Jones. Ms. Ross.
Aye.
Ms. Ross votes aye. Ms. Bush.
Ms. Bush votes aye.
Ms. Bush votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat. Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Issa?
Present.
Mr. Issa votes present. Mr. Buck? Mr. Buck votes no. Mr. Gates?
No.
Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stube? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes no.
Mr. Chairman, how am I recorded?
Ms. Lofgren, you are not recorded.
Aye.
Ms. Lofgren votes aye.
How's Macbeth recorded?
Ms. McBath, you are not recorded.
Macbeth votes aye.
Ms. McBath votes aye.
How is Johnson recorded?
Mr. Johnson of Louisiana?
Mr. Johnson of
that's correct.
Louisiana, you are not recorded.
Johnson votes no.
Mr. Johnson of
Mr.
Louisiana
Chairman?
votes no.
How is Ted Lieu recorded?
Mr. Liu, you are not recorded.
I vote aye.
Mr. Liu votes aye.
Ms. Dean?
Mr. Chairman, how is Cicilline recorded?
Mr. Cicilline, you are not recorded.
Cicilline votes aye.
Mr. Cicilline votes aye.
Are there any other members who haven't voted who wish to vote? The gentleman's appeal of the clerk will report.
Sorry, shit, hold on.
And tell Colleen to call me back.
Mr.
Ms.
Chairman,
Dean?
what are we voting? Yes?
Ms. Dean? You're on mute. Ms. Dean, you're on
Mr.
mute.
Chairman, how am I recorded?
Ms. Dean, you are not recorded.
Mr. Chairman, my apologies, it's Madeline Dean. How am I recorded?
Ms. Dean, you are not recorded.
You are not recorded.
Oh, I'm sorry, I couldn't hear you. Dean
You
is a
are not
yes.
recorded.
Dean is a yes.
Ms. Dean votes yes.
Clerk will report.
Mr. Chairman, there are 21 ayes, 17 noes, and 1 present.
The gentleman's appeal of the chair's ruling that the amendment is not germane is laid on the table. For what purpose does Ms. Ross seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
I want to thank you, Chair Nadler, and then Chair Johnson for bringing up this bipartisan, bicameral bill for the committee's consideration. You've heard about it both from the chairman and from my colleague, Congressman Bishop, and we were in the same law school class together, so I think it's kind of fun that we're here together doing a piece of joint legislation. But this is a very important bill for the service members at Fort Bragg, for the administration of justice, and for our judicial system. And I appreciate all of the bipartisan support. I also appreciate that both of our U.S. senators are in favor of this bill, and so I look forward to having it become law. And with that, Mr. Chairman, I yield back.
The gentlelady yields back.
Mr. Chairman,
For what purpose does the gentleman from Tennessee seek recognition?
would an amendment be in order that I believe Mr. Bishop would support to change the name of Fort Bragg to Fort George Holding? I withdraw.
Are there any more amendments? Hearing none, the question occurs on the bill. A reporting quorum being present. The question is on the motion to report the bill H.R. 2746 favorably to the House. Those in favor say aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 3239, a bill to make improvements in the enactment of Title 41 United States Code into a positive law title and to improve the code for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3239, to make improvements in the enactment of Title 41.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. One of the important responsibilities the House gives this committee is to oversee the revision and codification of the statutes of the United States. Keeping track of the new laws Congress passes every session is a formidable challenge, but it is an essential part of maintaining the rule of law in our country, and it is a duty we take seriously on this committee. The body of federal law is so large and complex at this point that it will be almost completely unmanageable without the United States Code. Currently consisting of 54 titles, the Code compiles the general and permanent laws of the United States into coherent subject areas. Many of us on this committee, for example, are familiar with Title 11 of the Code, which contains the bankruptcy laws, Title 28, which governs the federal courts, and Title 17, which contains copyright laws. The next title, Title 18, covers criminal law and procedure, a topic that occupies so much of this committee's work. The Code makes our federal laws accessible both to the government officials who work to fairly provide them. The Code did not appear magically out of thin air. Congress created it in 1926, and since that time, it has been painstakingly constructed and updated by expert lawyers working under the supervision of the House. We all owe a great debt to the Office of Law Revision Counsel, whose attorneys ably carry out their statutory mandate to develop and keep current an official and positive codification of the laws of the United States while maintaining strict impartiality as to legislative policy. H.R. 3239, offered by the gentleman from Wisconsin, Mr. Fitzgerald, and the next bill we will consider, H.R. 3241, offered by the gentlelady from Missouri, Ms. Bush, are amendments to the U.S. Code prepared by OLRC. Pursuant to the law governing their work, OLRC has submitted these bills to the Judiciary Committee for our consideration. These two bills contain amendments related to two titles Congress recently enacted into positive law, Titles 41 and 54. They contain purely technical changes that update the U.S. Code to reflect the new status of these titles. I want to make it very clear that these bills do not change the meaning or effect of existing laws. They are part of an ongoing effort to maintain the Code as an authoritative, accurate source of federal law. OLRC has submitted several other bills to the committee for our consideration, and I hope to schedule additional codification bills in the coming months. I would like to thank our colleagues for introducing these two bills, and I urge all members to support this legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. These next two bills, while maybe not the most exciting, are important, and I thank the chairman for his bipartisan approach to introducing each of the pieces of legislation. I also want to thank the Office of Law Revision Counsel. OLRC is a small but often overlooked office in the House of Representatives that is responsible for preparing and publishing the United States Code. They do tedious work of bringing order to the laws Congress enacts. As a result of their work, the law is more readable and accessible to the American people. The bills before us today make technical corrections to update internal references to Titles 41 and 54 throughout the Code. And as the chairman just stated, I understand that OLRC is working on a number of other similar projects and that we may, in fact, have more bills in the near future. I look forward to continuing this bipartisan work. Yield back.
The gentleman yields back. For what purpose? Without objection, all other opening statements will be included in the record. For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chair, I'd like to move to strike the last word.
Gentleman is recognized.
I rise in support of H.R. 3239. Judiciary Committee is responsible for laws pertaining to the codification and revision of the United States Code, as you just stated. Public Law 111-350, which was signed into law on January 4th, 2011, enacted certain laws related to public contracts as Title 41 of the United States Code. This bill makes technical amendments to update statutory references. These amendments update the code to reflect newly enacted law and make it easier to read and understand. I would like to thank the committee and the Office of Law Revision Council for their important work, and I urge my colleagues to vote yes on the bill. Yield back.
Does anyone else seek recognition? Are there any amendments to H.R. 3239? A reporting quorum being present, the question is on the motion to report the bill H.R. 3239 favorably to the House. Those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 3241, a bill to make improvements in the enactment of Title 54 United States Code into a positive law title and to improve the code for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3241, to make improvements.
Without
in the
objection, the
enactment.
bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. As I explained during consideration of H.R. 3239, this bill has been prepared by the Office of Law Revision Council and makes a number of technical changes to update Title 54 of the United States Code while making no substantive changes in law. I thank the gentlewoman from Missouri, Ms. Bush, for introducing this legislation. I urge all members to support it. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Mr. Chairman, I would just say ditto to yours and yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. For what purpose does Ms. Bush seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. This bill to improve Title 54 regarding the National Park Service and related programs would ensure that there is uniformity in the U.S. Code. It is vital for a country governed by rules and procedures that our laws be accurate and consistent. In my hometown of St. Louis, the Gateway Arch is a national park, home to the iconic St. Louis Arch, and it is governed and coordinated by the National Park Service and relies on what's written down in the U.S. Code. The bill will add in a purpose statement that, for example, acknowledges the urgency of preserving the Underground Railroad and recognizing its importance and the many, many sacrifices made by those people, my ancestors, who used the Underground Railroad so that they could be freed from tyranny and oppression, and the many courageous people who helped them. These technical fixes, while discreet, ensure that our laws and codes are up to date and readily available for our constituents, our courts, and practitioners to use. Thank you to the members of OLRC and all of my colleagues for their work on these legislative efforts. Thank you, and I yield my time.
Gentlelady yields back. Does anyone else seek recognition? Are there any amendments to H.R. 3241? Reporting quorum being present, the question is on the motion to report the bill H.R. 3241 favorably to the House. Those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. For what purpose does Ms. Jackson-Lee seek recognition?
Chairman, I'd like to strike the last word.
The bill has already been reported.
It's adrenal.
The gentlelady is recognized.
Yeah. Thank you so very much, Mr. Chairman. I was unavoidably detained, and I wanted to ensure my support for H.R. 2964, the Criminal Judicial Administration. Having federal courts in my district specifically, I want to acknowledge the importance of providing indigent resources or resources for indigent witnesses and others as relates to court dates of individuals that are not in custody. That's a very important part of judicial administration. I want to congratulate Mr. Jeffries. I want to congratulate Congresswoman Ross for the economies of scale in dealing with the question of providing access to our enlisted men and women or men and women on Fort Bragg to make sure that they can access the federal court in a reasonable period of time. I want to bring to the committee's attention a particular procedure that most members are not aware of. And let me also thank Mr. Johnson for his great leadership of this committee and his ranking member dealing with the administration of courts. Also acknowledge Congresswoman Bush for any time I hear the words Underground Railroad, I know that this is an important initiative to clarify and ensure that this historic train of freedom is always included in front and center. Thank her for her leadership. But I wanted to bring to the attention of our colleagues a prerogative that may be a little unknown and striking with respect to court administration, and that is the authority of the particular districts to move courts as they so desire by the judiciary present in those districts. Meaning if you have a very, very large district, such as the Southern District, the unnoticed right of judges to precipitously pick up and move a court that has been established in one city or locale versus another. Most people dealing with the courts have no idea. Most people don't know that the judgments are not made fairly and unbiased if you move from one crowded agenda area in terms of court docket to another. So we've had that controversy in the Southern District, and it deals with a very historic position that may ultimately become vacant. It's something that I hope to reach the Courts Administration Committee to be able to say that these courts, even though it is a separate third branch of government, rightly so, but the people should also be considered when such drastic decisions are made of relocating a court miles and miles and miles away, which is why Congresswoman Ross and her co-sponsor had such a very thoughtful initiative to provide for opportunities for the residents at Fort Bragg. We have quite the opposite, and I think we should be aware of that, and I will continue my discussions with the committee on that very point. Mr. Chairman, thank you so very much. With that, I yield back. Support the legislation that we've just passed. Yield back.
The gentlelady yields back. This concludes our business for today. Thanks to all of our members for attending. Without objection, the markup is adjourned.